So you fired those 12 people. They were experts on Iran, were they not?
I don't believe so.
They worked in counterintelligence, did they not?
I'm taking you at your word, sir. I'm not familiar with every
You're the
single
chief
word.
director. I'm not. You should know the answer. You fired the people. Where did they work?
People were terminated for violating their ethical obligations and the high standards.
Was
that
the
we
ethical
have.
violations that they dealt with the case of the classified documents that were found in the bathroom in Mar-a-Lago, was that the ethical issue?
As I said earlier, all those matters are pending litigation, so I'm not going to comment.
A significant legal confrontation is unfolding as former FBI agents escalate their dispute with the Bureau's leadership by filing suit in federal court, transforming what began as a congressional hearing into a formal judicial test of employment protections and political influence within federal law enforcement. The case centers on allegations that personnel decisions were motivated not by performance or misconduct, but by the targets of ongoing investigations, specifically connections to former President Donald Trump. This represents a rare instance where internal agency disputes have spilled into open litigation, potentially exposing the decision-making processes of senior officials to judicial scrutiny and discovery procedures that congressional testimony alone cannot compel. The plaintiffs contend that their terminations violated established civil service protections and constitutional safeguards against politically retaliatory dismissals. Legal observers note that federal employment law generally requires cause for removal of career civil servants, and that alleging partisan motivation as the primary driver for termination opens multiple avenues for judicial relief. The case forces consideration of where legitimate executive authority over agency personnel ends and where impermissible political interference begins, a boundary that courts have historically policed with varying degrees of stringency depending on the administration and the specific security context involved. From an institutional perspective, this litigation arrives at a moment of acute tension regarding the FBI's operational independence. The Bureau has historically maintained that its investigative decisions remain insulated from political direction, a claim that becomes harder to sustain when career agents publicly allege that investigative targets influence their employment status.
So my specific question is that there was a report that came out in February from CNN that the FBI had let go or fired dozens of agents and staff members from a counterintelligence unit tasked with monitoring Iran. And apparently the reason, at least reported in the press, was that these individuals had been involved in the investigation of classified document handling from President Trump at Mar-a-Lago, and that this was the reason why they were summarily let go. First of all, are you aware of those firings, and do you concur with the rationale or reason for those firings?
I'm aware of that, and I know there's a pendency of litigation, so I'm not able to comment on them.
Did you yourself order those firings?
The FBI, every time there is someone who violates their code of conduct or ethical standard, conducts an internal investigation with the careers there, and they present a decision point to me. The Iranian Threat Mission Center has seen an increase of 43% in arrests for Iranian spy actors. So the Iranian Threat Mission Center has never been stronger.
So I'm asking about whether those people were fired because they were involved in the investigation of the document handling by President Trump, not for any behavior issues. Is that your understanding as well?
Again, ma'am, I can't comment on them because those are in pending litigation.
I guess I'm a little stymied here, Director, because it feels as though literally when there was a possible pending war, I'm outside of this intelligence circle in many ways, even though I serve on the Intelligence Committee. You collectively must have been aware when these firings happened that there was a meaningful chance that the U.S. might be engaged with a war in Iran. And having these very expert, super qualified folks summarily dismissed at this time, it just feels like an odd choice in timing. Were you aware at the time that this was going down, that this may end up weakening the mission and the readiness of that group?
The mission, as I stated, has never been stronger when you see a 43% increase in counterintelligence arrests and 21% increase in cyber arrests against the Iranian Threat Mission Center. My focus is on providing the American people the strongest FBI as possible. I don't work on timelines. I work on evidence that's presented to me.
I guess my concern is that it feels as though, and I very much honor the tone and tenor of this hearing, that this is about making sure that that we depoliticize what is the most important thing that we all do, which is keep us safe. And it feels as though this issue is a political issue, and I just am worried that we are taking really good, really qualified people and picking fights with one another across party lines, rather than making sure that we.
Should discovery reveal communications between political appointees and bureau leadership regarding specific personnel files, the resulting documentation could fuel separate oversight investigations and complicate ongoing congressional scrutiny of the agency's recent restructuring efforts. The involvement of Kash Patel as a named defendant adds significant weight to these proceedings, given his current position directing the bureau and his previous public statements regarding the need for personnel changes within federal law enforcement. Plaintiffs will likely seek to establish a pattern of statements or directives suggesting that loyalty assessments superseded traditional performance metrics in retention decisions. Defendants, conversely, will argue that organizational restructuring and performance-based evaluations fall within legitimate administrative discretion, and that plaintiffs have failed to meet the legal standard for proving prohibited motivation. The transition from congressional testimony to federal court carries substantial procedural implications. While agency officials could invoke litigation privileges to avoid answering specific questions during legislative hearings, those protections largely dissolve under the federal rules of civil procedure. Discovery obligations will require document production, depositions under oath, and potential testimony from senior leadership regarding the specific circumstances surrounding each termination. This procedural reality significantly raises the stakes for all parties, as inconsistent statements between congressional and judicial proceedings could expose participants to credibility challenges or, in extreme cases, separate proceedings regarding truthfulness under oath. The broader significance of this case extends beyond the immediate employment disputes to touch upon fundamental questions of executive power and agency accountability. Federal courts have historically afforded significant deference to presidential administrations regarding personnel matters within the executive branch, but that deference has never been absolute. Cases establishing that civil service protections create enforceable property interests in continued employment provide the doctrinal foundation for these claims, though courts remain cautious about becoming arbiters of internal agency management decisions absent clear statutory or constitutional violations. Analyzing the evidentiary landscape, plaintiffs face the substantial burden of proving that protected activity, investigation of politically sensitive matters, was the but-for cause of their terminations. This requires more than demonstrating temporal correlation or general institutional hostility towards certain investigative priorities. Successful claims typically require documentary evidence, witness testimony, or admissions establishing a direct causal link between specific investigative work and subsequent adverse employment action. The absence of such concrete evidence has doomed similar claims in previous administrations, suggesting that these plaintiffs must present particularly compelling proof to survive likely motions for summary judgment. The defense strategy will almost certainly emphasize the extensive authority Congress has delegated to the FBI director regarding workforce management and organizational structure. Arguments will likely characterize the challenged terminations as components of legitimate efforts to improve efficiency, address misconduct, or realign investigative priorities with current threat assessments. Defendants may also invoke national security concerns to resist broad discovery requests, arguing that disclosure of personnel deliberations regarding sensitive investigations would compromise ongoing operations or reveal classified methodologies. From a political communication standpoint, this litigation creates complex messaging challenges for all involved. Administration officials must defend personnel decisions without appearing to disparage career law enforcement professionals or validate allegations of politicization. Plaintiffs must maintain that their claims represent principled stands for institutional integrity rather than sour grapes from terminated employees. The judicial forum, with its emphasis on documented evidence rather than rhetorical positioning, will test these competing narratives against admissible proof rather than public opinion polling. The potential for this case to generate precedent regarding political interference claims cannot be overstated. A ruling establishing that investigative assignments touching upon elected officials receive heightened employment protection would create significant constraints on future agency leadership. Conversely, a decision affirming broad discretion to reassign or terminate agents regardless of their investigative portfolios would narrow the scope of civil service safeguards in politically sensitive contexts. Either outcome would reshape the legal landscape for federal law enforcement employment disputes. Procedural developments to monitor include the scope of permitted discovery, any assertions of executive privilege regarding internal deliberations, and the treatment of classified information under the Classified Information Procedures Act. These technical matters will substantially influence the practical impact of the litigation, regardless of the ultimate merits determination. Cases involving sensitive government functions often resolve through negotiated settlements precisely to avoid the risks associated with extensive discovery into operational matters, suggesting that settlement discussions may occur alongside active litigation. The relationship between this federal case and ongoing congressional oversight presents additional complexity. Committees may seek to incorporate judicial developments into their own investigative frameworks, while parties to the litigation could resist providing testimony that might compromise their litigation positions. This interplay between judicial and legislative fact-finding channels often produces friction regarding the timing and scope of information disclosure, with courts generally reluctant to halt congressional inquiries but protective of their own case management authority. Evaluating the institutional stakes, the FBI's credibility as an impartial investigative agency hangs in the balance regardless of the litigation's outcome. Public perception that personnel decisions correlate with investigative targets corrodes the essential trust required for effective federal law enforcement. The Bureau's leadership must navigate these proceedings while maintaining operational effectiveness and workforce morale, a challenging equilibrium when senior officials are personally named as defendants and required to testify under oath regarding their decision-making processes. The specific allegations regarding investigations connected to Donald Trump introduce distinct legal and political dimensions. Claims that investigative work regarding a former president triggered professional retaliation touch upon sensitive constitutional considerations regarding the separation of powers and the appropriate scope of executive branch accountability mechanisms. Courts examining such claims must carefully distinguish between legitimate supervisory oversight of investigative priorities and impermissible punishment of career professionals for conducting investigations that produce politically inconvenient outcomes. From a remedies perspective, successful plaintiffs could potentially obtain reinstatement, back pay, injunctive relief regarding future personnel actions, or declaratory judgments establishing the unlawfulness of specific termination rationales. The availability and appropriateness of these remedies will depend upon findings regarding the severity of any procedural violations and the feasibility of restoring productive employment relationships given the public nature of the underlying disputes. Courts remain cautious about ordering reinstatement when interpersonal relationships have deteriorated substantially, often preferring monetary compensation in such circumstances. The defense of qualified immunity may arise regarding individual supervisory defendants, though this protection applies to constitutional violations rather than statutory employment claims. Should plaintiffs successfully plead constitutional dimensions to their retaliation claims, individual defendants may seek dismissal based on the absence of clearly established law regarding the specific conduct alleged. This procedural posture could delay resolution of claims against individuals even as organizational liability proceeds toward trial or settlement. Comparative analysis with previous federal employment litigation suggests that cases involving high-level political appointees and sensitive investigative matters rarely proceed to final judgment. The costs and risks associated with extended discovery into national security operations typically motivate settlement negotiations, often resulting in confidential resolutions that provide financial compensation without formal admission of liability. Whether this case follows that pattern will depend upon the parties' respective risk tolerances and the strength of the documentary record developed through preliminary discovery. The media coverage dynamics surrounding this litigation merit consideration given the intense public interest in FBI operations and Trump-related investigations. Judicial proceedings offer less opportunity for selective disclosure than congressional hearings, with public dockets and formal evidentiary requirements constraining the ability of parties to shape narratives through strategic leaks. This procedural regularity may ultimately provide a more reliable factual foundation for public understanding than the competing spin environments that characterize political oversight processes. Assessing the plaintiff's litigation strategy, the decision to name senior leadership personally rather than merely suing the agency suggests an effort to maximize pressure for settlement and to establish individual accountability for allegedly improper decisions. This approach increases potential recovery, but also raises the stakes for defendants who face personal financial exposure exposure and reputational consequences extending beyond their government service. The tactical wisdom of this approach will become clearer as discovery reveals the extent of personal involvement by named defendants in specific termination decisions. The institutional response from the FBI Director's Office will require balancing defensible legal positions against broader workforce management concerns. Aggressive litigation tactics risk alienating career agents who may view such approaches as confirming allegations of leadership hostility toward traditional professional norms. Conversely, insufficiently vigorous defense could encourage additional litigation from other terminated employees and undermine administrative authority. This management dilemma illustrates the complex interplay between legal strategy and organizational leadership in high-profile employment disputes. From a constitutional structure perspective, this case implicates enduring tensions between presidential control of the executive branch and statutory protections for career civil servants. The Supreme Court has historically recognized that Congress may impose limitations on removal authority to preserve agency independence, though the precise boundaries of such limitations remain contested. This litigation may contribute to the evolving jurisprudence regarding the scope of permissible congressional constraints on executive personnel authority, particularly in contexts involving law enforcement agencies with traditional claims to operational independence. The evidentiary challenges specific to proving motivation in employment decisions deserve attention. Direct evidence of prohibited intent is rarely available in politically sensitive terminations, requiring plaintiffs to rely upon circumstantial proof, including timing of adverse actions, comparative treatment of similarly situated employees, and statements by decision-makers. The strength of such circumstantial cases varies substantially based upon the specific documentary record and witness testimony available, making early discovery outcomes critically important to case assessment. Procedural timeline considerations suggest that resolution within the current administration is unlikely absent settlement. Federal employment litigation typically extends across multiple years when contested. An appellate review of significant rulings further prolongs final resolution. This temporal reality means that the litigation's political impact may substantially exceed its ultimate legal significance, as ongoing proceedings provide continuous fodder for oversight hearings and media coverage regardless of eventual merits determinations. The potential for this case to influence legislative reform of civil service protections warrants consideration. Should litigation reveal gaps in current statutory safeguards or practical limitations in judicial enforcement mechanisms, congressional committees may propose amendments to the Civil Service Reform Act or related legislation. Such reform efforts would face the familiar obstacles of partisan disagreement regarding the appropriate balance between executive flexibility and employee protections. But concrete litigation outcomes could shift the political calculus regarding reform feasibility. Analyzing the broader pattern of federal employment disputes during presidential transitions, this case represents an unusually public and legally formalized example of tensions that typically resolve through administrative processes. The decision by terminated agents to litigate rather than pursue administrative appeals exclusively suggests a judgment that traditional employment dispute resolution mechanisms offer insufficient protection or visibility for the alleged violations. This strategic choice reflects both confidence in the underlying legal merits and a desire to publicize concerns regarding institutional integrity that administrative proceedings might bury in confidentiality. The intersection of this litigation with potential criminal proceedings or ongoing investigations creates additional complexity regarding witness availability and testimony coordination. Plaintiffs who are also potential witnesses in separate criminal matters may face strategic decisions regarding the scope of their civil discovery participation to avoid compromising their positions in other proceedings. Similarly, defendants must navigate discovery responses without waiving privileges or creating inconsistencies that could affect separate legal exposure. From a professional responsibility standpoint, the attorneys representing both sides face significant obligations regarding candor to the tribunal and protection of client interests in a high-visibility context. The temptation to use litigation as a vehicle for political messaging must be balanced against disciplinary rules prohibiting misleading representations and the practical consequences of overpromising to clients regarding likely outcomes. These professional constraints may exert a moderating influence on litigation rhetoric even as public statements outside court remain heated. The ultimate significance of this case will likely be determined less by the specific remedies awarded to these particular plaintiffs than by the legal principles established regarding the scope of protected activity for federal law enforcement government personnel. A ruling that expansive investigative work regarding elected officials receives categorical employment protection would substantially constrain future agency leadership. Conversely, a narrow reading of protected activity would leave career agents vulnerable to retaliatory reassignment or termination when their work intersects with political interests. Neither extreme seems likely, with courts typically seeking contextual balancing that preserves both investigative independence and legitimate supervisory authority. In conclusion, this litigation represents a critical test of whether statutory employment protections can effectively constrain politically motivated personnel decisions in federal law enforcement. The case forces confrontation with uncomfortable questions regarding the adequacy of existing safeguards and the willingness of federal courts to police the boundary between legitimate administrative authority and impermissible political interference. Regardless of outcome, the proceedings will generate substantial documentary record regarding recent personnel decisions, providing foundation for ongoing oversight and potential reform. The judiciary's handling of discovery disputes, privilege claims, and ultimate merits determinations will shape the practical landscape for federal employment disputes for years to come, establishing precedents that influence behavior far beyond the specific parties to this controversy. The stakes extend beyond individual employment remedies to fundamental questions of institutional integrity and the rule of law within federal law enforcement. Questions that resist easy resolution, but demand careful judicial attention to the competing values of executive accountability and employee protection.